Me again, cannabis industry lawyer Tom Howard. You can find me over at cannabisindustrylawyer.com or our law firm's website, collateralbase.com. And now we're going to discuss the dispensaries that are coming to New York State this summer. There should be an application window. And then I hope that application window is more like New Jersey than Illinois, in the sense that application windows can open and shut real quick. The shortest application window that I've seen so far was West Orange, New Jersey. It was 8 or 9 days. It came out on a Wednesday. It was due next Friday. They wanted more than just what was in the conditional application. And that's tough, because that means that you had to have gotten them approximately over 100 pages of narrative work product within that time. And so that's just breakneck speed. I hope it's not like that. I hope it's going to be more along the line of just regular New Jersey, where they telegraph it. They say it's coming. Here's what's in the application. We will begin accepting them on such and such day. And they just begin accepting them and processing them. And that's where I hope these, as the New York Times reported in March of 2022, the OCM, that's the Office of Cannabis Management out of New York, they have reserved the first 100 dispensaries for equity-involved applicants. A completely new legal term of art that we're going to be going over. It's a very insular and select minority. I mean, it's so difficult to be one of these people. There's not that many of them in the state. And of course, regulations in the draft, 35 pages. For part 116 for the conditional adult use dispensaries, they have been released. We're going to be going over those regulations right now. And there doesn't appear to be any numerical limits regarding the number of dispensaries in the states. At least I haven't seen any yet in the MRTA, that's the Marijuana Regulation and Tax Act. Prove me wrong. I hope that doesn't become the case, but there's no numerical limits as far as I'm aware for the number of dispensaries. And Section 80 of the MRTA, the MRTA, they do put vertical integration limits. So it's similar to Washington State. You have to pick a lane. You can grow it or you can sell it. You can't do both. It's more difficult to do both. So what is in it? Oh, this is something that I always like to do when people are talking about getting a dispensary in a regulated state, and a new state comes online and it's going to be fairly regulated. I'm like, let's talk about what a simple dispensary looks like in the highly regulated space that is cannabis. This was provided to us by the Illinois Department of Federal Financial and Professional Regulation when they did their application window back in 2019. So you have this licensee LLC, this little thing at the bottom. And then you got all these LLCs floating around it, and even a publicly traded cannabis conglomerate incorporated floating on top of it. And you have a pass-through LLC, and then you have a management LLC, you have a holding company LLC, and then you have this licensee LLC. Well, it's this licensee LLC in the middle. That has to be justice involved ownership. That has to be the eligible LLC in the middle. And then you have the holding LLC, which is like the landlord, the real estate play at the side. And then you have that management LLC at the other side. And that's kind of like doing your PEOs, your back ends, your administrative, all the other type of stuff that you're not allowed to deduct. And then you have that pass-through LLC. And that's just kind of, that's a place where the money goes to pay the taxes and then flow through. And then it goes all the way back up to the publicly traded cannabis conglomerate in New York State. That would be Columbia Care, or soon to be Cresco. This is essentially what Cresco does with each one of their multiple dispensaries. Anyway, well, I don't think they have any social equity ones yet. This would still be the organizational structure that they would then do for asset protection and allocation, to protect the assets and shield them, and kind of you put an asset into an LLC so that you've limited its ability to have that value that's in there, and also you've shielded its risk. So like if something goes wrong with that LLC, it's not going to affect the management company and the real estate company and yada yada. Okay, just a simple retail store, right? Okay. Section 116.4 of these new regs, and we're going to be going over them after we go over this large trends as well. We'll be sharing these, but the most important section, I'd say, after what goes into the application, because why would you even look at what goes into the application if you can't figure out if you're even eligible for an application and an evaluation. So the eligibility requirements are in that 116.4 section. And that's where you need to be justice involved. And that's 116.4 A21, Roman numeral 1, tiny 1. And then they also talk about what constitutes a qualifying business, because it's not enough. It's not enough just to be justice involved. No, you also need to qualify. And then they talk about something else, which I had to read 3 times because it was like in Arrested Development, when something can't, no more than 3, but no less than 5. What does that mean? It was one of those deals. But if you read it enough, you're going to see that an applicant control minimums, 51% of the total under 16.4 for a justice involved in a qualifying business means that it has to be a 51% of the total of the qualifying business must be justice involved. And 30% of that 51% has to go to just one guy that has sole control. And then, not only that, they're also going to now start nitpicking this social, well, it's not called social equity, it's called justice involved applicant to see how much street cred kind of that they have. Like a justice involved applicant that was arrested in the poshest neighborhood won't be as important as a social equity. Doing it again. Justice involved applicant that was arrested in an impact zone or an economically disadvantaged zone, depending on what the OCM decides to call theirs. I hope they call them DIAs, so I don't have to learn any more acronyms. But very often the aspects of social equity are not only the arrest or conviction for marijuana, but also a long-time residency in an area of the country that was disproportionately injured by the failed drug war, which is still going on. I mean, like, we can't sell tickets to this thing. This is a federal crime. They actively censor our industry, and I think that's one of the reasons why cannabis prohibition's hanging around so long, and that other groups that have been injured over the past have been able to access their rights quicker, because it's not a crime to be them. It's not a federal conspiracy if they're trying to get their message out like it is for cannabis businesses. Okay, let me see what our next one is. Yeah, and now I'm going to take this off for a minute, and we're going to dig into the very specifics of the definitionals. And so with that, I'm going to zoom in on part 116. And we go to these regs, and both these regs, and then also these materials, they've been produced and provided, of course, by the OCM. So far, very impressed with New York's website, very nice interface, and they seem to have a lot more transparency than certain Midwestern states. And they also, New Jersey did a very good job, and New Jersey's doing a very good job, in my opinion. And I hope that they are going to do more of that and less of what Connecticut is just very difficult to navigate their stuff. But Connecticut also has an application window right now for social equity that is closing in about a month. So let's go back to section 116 and dig into the eligibility aspects of it. And then we're going to talk about what's actually in the application. So once we find, and that's one of the reasons why your team is so important when it comes to your dispensary, because you need to have the justice involved, and then you need to have a qualifying business, and then it needs to be just in the right neighborhood too, to put you over the line into that 100. And then, we'll talk about the risks, very similar risks, because they've essentially painted everybody else out of a corner or into a corner and said only these 10 people in the whole state. And it's not 10. It's probably 1 million or less. Well, because the way they've defined it, it has to be more than 1 million, as they've gotten generational, even spousal in the definition. Let's go to the eligibility. Okay, so they have to demonstrate first a significant presence in New York State, and maybe a dormant commerce clause challenge coming, but those happen all the time in this industry. And then be justice involved, which means that, and I'm going to zoom in on this one, convicted of a marijuana-related offense prior to when it became enacted, or, and then this is where it gets intergenerational and also spousal, legal guardian, child, spouse, or dependent who was convicted. Was dependent of an individual, and see, were you their kid, or was it you, or was it your spouse? And then they want to know where you live. And so it's not that they look for the arrest. I'm sorry, the conviction. New York is also a conviction state. Some other states, it's the arrest. This one is the conviction. And then they have and hold, and this is an interesting one. Suddenly now you have to be, for a minimum of 2 years, at least 10% ownership in and control of a qualifying business, which means a business that had a net profit for the last 2 years, the business was in operation, or if the application is a nonprofit and nonprofit organization. So now, how many people can click them boxes, right? How many people can say spousal, generational, all right, find the marijuana convictions in the state of New York. Look at their family tree. Which ones are in business, small business, which ones for the past 2 years have posted a profit. That is the entire sample set of eligible applicants. That's it. I don't know what the answer of that question is, but it's a finite one. There's only so many people. Is it 1 million? Maybe. So like 1 out of 20 New Yorkers might be eligible for this. They created a law that says 95% of the people that reside in this state can't do this industry. Just to start, that's the thing. When they make laws too special, equal protection and due process challenges can start to arise, even if they do say that this is a privilege and not a property right, which they often say. So now you're going to have a lot of 501c3s getting formed right now. Because the pool of equity involved applicants that haven't, at least for the past 2 years, turned a profit in a business of which they own 10% is probably larger than the ones that do have the business. And there you go. And so that's one of the ways that they have made this exceedingly complex. And here's the other stuff where it gets interesting. Applicant controls and minimums. The subsection B on this, 51% or more has to be one of these qualifying that we went through. That's A1 and A2. That's the conviction or in the spousal and the familial convictions. And satisfies the requirement for an eligible applicant in A1 and A3, and any other individuals, if any, who are social justice involved. And then they almost have the exact same paragraph here, but then shall own at least 30% of the applicant, and such individual or entity shall have sole control of the applicant or license. And then you see here it's at least one individual, and here it says 51% or more. So now, the wickets are just getting smaller and smaller as you read this, and we haven't even looked at what the application entails. Jay Sharkowski and Canon Advisors should have no problem charging their reasonable $100,000 that they charge to do their services for an application like this. And that, it's like, anyway, we're going to get to that real quick. I just wanted to kind of belabor the point of how insular of a number of people that are going to be able to actually qualify for this. And so when people want our help over at Collateral Base or Cannabis Industry Lawyer to help them apply for their licenses, yeah, no problem. I give you a perfect application. But if you don't hit all those wickets, what's the point, And with that, I think we should, and then the evaluation. I want to cover the evaluation on this first, because we just did the control minimums. And so now I want to do the evaluation, and then we'll get to the contents of the application as far as we know them so far. So the evaluation: an eligible applicant shall be evaluated based on any of the following criteria as weight determined by the office. That's the OCM. The application is an individual were they themselves convicted of the marijuana crime. And then relative to these areas, where did they live at the time of such conviction? And that's really, really interesting. So that's something that it's just restricting it. And the more you look at it, the more restrictive it gets. And now let's have some fun and go to the second section. I'll say it's the application. It's 116.2. So there we go. And let's blow this up. This is what goes into this application, right? And it starts inauspiciously. Legal name. And then the name under which they want to operate or make sales if different. And that's nice. Jersey, you have to use the same name. Other states, you're allowed to do DBAs. Looks like New York allows that as well. Address and date of birth. where the applicant and each true party of interest of the applicant. So your LLC needs an address. Remember, one of the ways that you could be eligible is that you had a business that turns a profit for the past 2 years. So that should be pretty easy to do. That's the trick about this one. If you got it, you don't need it. If you need it, you got it, right? A copy of a valid photo ID, that's not that bad. Personal history disclosure, those can be tricky. Personal history disclosures are sometimes check the box. Sometimes they're quite long. New Jersey's was quite long, about 14 pages. Submission of fingerprints, common. Ownership structure of the applicant, kind of common. It'll probably be done in a cap table and or a org chart, maybe even both. Percentage of ownership held by true party of interest in the applicant. They define these true party of interest. They define financiers in this. List of all parent companies, subs, affiliates, predecessors, successors. Yep, and this aspect of it really makes it more difficult and complex for the MSOs to apply, and New Jersey did this as well. So if you were a fresh LLC startup that qualified for social equity, they call it there, justice involved as they call it here, it is streamlined because you don't have to fill these things out. Like if you are one of those companies and like you were convicted and then you became a roofer, you own a roofing business, you've been profitable for 10 years, that's it. They want you, especially if you were arrested in a terrible area of town. You got the golden ticket, man. It's just good luck trying to find you. And then also good luck trying to get this information because of censorship. Again, I can't put an ad in front of your face about this. Anyway, those people that aren't, they're closely held companies, 1-2 owners, these types of disclosures, much more streamlined. I don't really like seeing big teams or publicly traded teams like that, because then I know like, oh crap, the heavy lifting on this, I'm gonna have to charge you more because it's gonna take a lot longer. It's a lot more complex application than if it's a startup or a company that has been closely held and that would be eligible as a business in this respect. Okay, let's continue to move on. The names of the financial institutions. Now this is where things are gonna be tricky. It's like, you were a roofer and now it's like, and now we wanna start selling weed. Might have an issue with banking. And then current chart, org chart, and then look at that. They keep going on. They want to know everybody, all the people, all the seats on the bus, all resumes, all their skills, all their education, all their experience. Organizational documents. Now that's your LLC stuff. So the more corporate and complex, the more people on the cap table, the more shareholders, the larger this application number 12 will be. The single member LLC, no debt, nothing like that, doesn't owe nobody anything. 4-page operating agreement maybe, but that's not typical in the cannabis industry. Okay. If the applicant is not an individual, description of the formation and all ownership changes. They want to see who's been a partner, who is a partner. All compensation agreements between the applicant and each true party of interest. That would be like if your consultant wants equity kickers as a bonus, or they want a success fee as a bonus, or if you are justice involved and you've been hanging $50,000, $60,000, $80,000 on your designers and your architects and your accountant and your lawyer and all your other people, say as soon as we get open, we'll pay it. And then those would also be included in your number 15, any proposed executed contract, term sheet, agreement, side letters between the applicant, true parties of interest. Those are there. And then they also want to know your bonds. Number 17, audited financial statements. Audited financial statements for a startup, much shorter than audited financial statements for a company that's been in business for 10, 15 years. All sources of funding. They want to know all sources of funding. Details of state and federal administration proceedings. You see that a lot, very often. Those are check the box. Have you ever lost a license? Have you ever been sanctioned? Have you ever stolen money? Manage or service the board, business or nonprofit, pled guilty to fine, had a receipt. That's in there. Information related to a business community plan. That is going to be some narrative work product. I can't wait to see the regulations on this, because then this related to a business continuity plan. There's probably going to be some type of regulation in there about how you are able to pass this on to either the community or to generational wealth. Certificate of good status or good standing, common. Applicant of true parties of interest, same. copy of each license or verifying license. That might be one of those things. If there's, depending on what the business does, it requires licenses to be able to operate. For example, you're a lawyer, you probably have a law license. You're a doctor, you probably have a medical license. That type of stuff. If you're a beautician, I'm sure there's a license involved. Yeah. Management agreements. And so let's say that you are that roofer and you're like, well, magically I qualify. It's golden ticket, might as well. And then somebody else, maybe in Colorado, maybe in California, maybe in Oklahoma, maybe in Michigan, states where they have open and vibrant cannabis markets, they might say, we'll manage your dispensary for you, sir. You go back to fixing roofs and collecting those checks. That would be what you would then have to tender to them. And the list of the vendors out of compliance has been disciplined or sanctioned. So we're only on number 29. And so far they have been kind of like administrative. They haven't had a lot of compliance narrative. Let's see, insurance. That's usually a one-page LOI from 9-point insurance information may exist between them. Okay, and then like board relationships. Trying to prevent any types of window dressing or sham transactions. I would imagine. Information regarding compliance with sections 1116A41. So that we're going to have some type of documentation that we're going to have to prepare and submit to the OCM that evidences your eligibility. And they've already gone over what they're looking for, so they'll do the job right. They'll give you a list. They'll have an attestation. They have one in New Jersey. It's 4 pages. We're looking for these documents. We're looking for those documents. Sign here, get it notarized, scan it in. We can help you set all that stuff up. Any additional information requested by the office, and then general. So it's 34, 35 aspects of it. It's going to be a dense application, but it's not necessarily, so far, at least when it comes to the conditional, it doesn't seem like it's asking for a lot of the operational requirements that you need. For example, when we were going over the hemp stuff, we were talking about various plans and protocols and procedures, those types of narrative work product things. Those are also going to be in your dispensary. However, they just haven't specified them as yet in that application. And they do say any additional information requested by the office. This is a conditional. This is not full right. And so what you're seeing in the industry currently, and Illinois is even adopting this for their next round of dispensaries, you see a conditional process which asks for a lot of that structural, administrative type of compliance issues where they aren't really asking for the narrative work product to demonstrate compliance with the regulations for how you're going to operate. They're just making sure they know how you're structured, if you're eligible, who's getting paid, what they're getting paid, all those types of things. And then, you allow yourself to be fingerprinted in background checks, and you check boxes to determine if you are a felon. Well, felons are not automatically disqualified. It depends the type of felon. Anyway, I believe that kind of wraps up the stuff. One of the things that we like to do at the shop is we make, and this is for our clients, in our application mastermind section. Now we'll be adding these checklists. This one for the New York cannabis cultivation application. So we go through and we would punch each one of these things out as we are building out the application. We also have it for the, and then we have tabs down there at the bottom. We also have it for the dispensaries, at least as far as we know it. Like these checklists that we make are going to get even more built out after the regulations hit, which we anticipate in approximately a month. So thank you very much for tuning in to our broadcast. And if you enjoy this, smash likes, click subscribe, visit us over at Cannabis Industry Lawyer, and consider becoming a member or a client of Collateral Base. Thanks, everybody, and I will see you when it's 420 somewhere.